Hello, this is Ben Bange from Taylor Wessing. Welcome to our webinar today. Today's webinar is part of our monthly webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have included issues such as cookies and tracking, data security, mobile apps, data transfers. We've also looked at more topic-specific issues recently as well, such as BYOD, or bring your own device, and last month we looked at the topic of wearable privacy. Recordings of those webinars are still available if you missed them and you still wish to engage with us on those particular topics. Today we will be taking a look at the topic of HR data protection issues, particularly from an Anglo-German perspective. For those of you who are new to Taylor Wessing or new to our monthly webinar program, welcome to you. As you will see from the slide, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and also into Asia. And we've listed more details about the firm on the slide deck for your reference. Today's webinar is actually brought to you by Taylor Wessing's International Data Protection Practice. Our team advises on all aspects of data protection and information law and does so from our office footprint, which is a global 22-partner-driven team. It's also complemented by our international network of data privacy law specialists from jurisdictions where we do not have an actual footprint, to give you a genuine global one-stop shop offering. We're proud to have launched this year our brand new microsite, and this is very specifically for all things data protection. And this is Taylor Wessing's Global Data Hub. From this site you'll be able to access, amongst other things, news, which is presented by our weekly update, and also if you decide to register, you'll be presented with a monthly mail shot when new content is added to the Global Data Hub. And this is usually done on a monthly issue where we present on a particular topical issue. We will look at some of those issues that are raising concerns or just challenges for the sector or the privacy community at large. This month our articles also feature on the topic of today's webinar. You can access webinars, you can register for forthcoming webinars, events, and also, as I mentioned earlier, if you want to listen to webinars that we've already presented and have recorded, those are available completely for you at the Global Data Hub. We also feature what we refer to as our groundbreaking risk maps. These maps will provide you with an at-a-glance view of data protection issues, with an interactive feature for different countries against different question sets, so you can have an at-a-glance view of how different countries are impacted by different data protection laws and considerations for different countries. The presenters for today's topic will be myself. As I said, my name is Ben Bange. I'm head of the UK Data Protection Practice here at Taylor Wessing in London. And today I'm delighted to be joined and be presenting alongside Thanos Ramos, who is a member of Taylor Wessing's Data Protection team based in Munich, in Germany. And our profile information is there on the slide for your reference. So, what are we going to cover today? Well, today is very much a primer on human resources data protection issues, except with a slight difference in that we're going to be taking a look at this subject from not only a UK perspective, but also from a German perspective. And so often we see that multinationals have operations not only in the UK or other countries across Europe, but often multinationals will have headquarters in the UK, but also have significant or HQ operations also in Germany, and often, as we see, in both of these key jurisdictions in Europe. So it seemed right that we bring you an Anglo-German view for particularly a topic such as human resources, which impacts on so many different organizations. In terms of what we're going to look at today, I'm going to start with in a moment just taking a very quick look at the HR lifecycle. Then I'm going to be spending just a couple of moments looking at the current legal framework and reflect on how that interfaces with human resources as an operational aspect of your organization. Then we're going to look at 4 specific areas, looking at the pre-employment stage, the employment stage, and then looking further at issues such as emails and monitoring, and also disclosure issues by way of subject access requests. And we'll look at these in the context of UK issues and also from a German perspective. As far as the life cycle is concerned that I mentioned, I mean, this is very simplistic, but I think quite reflective in a very accurate way of what many organisations see and how many organisations typically divide up their HR operations. You will start quite simply with a pre-employment stage. This is a stage where you haven't yet formally employed a particular individual, where you might be engaging with an individual in terms of formal interviews or perhaps even informal meetings and discussions, which then often become more formal as you make a decision as to whether or not this is an individual that you would like to engage and bring into your organisation. And still at that pre-employment stage, you may have vetting and pre-employment checks, all of which then begin to gather real pace in terms of the information and therefore the personal data that's been collected. As the employee then moves to the final stages of pre-employment, then quite simply you're faced with a decision. You either recruit the individual, so there is a yes decision, a go decision, or there is a no. This isn't someone you want for whatever reason, and you will then decline the applicant. Where you decline the applicant, there will still be an element of personal data that you would retain and have collected to date. But then if you engage the person and make them an offer of employment, then you'll find that that employee moves into the employment stage, and there is another set of data that's collected in relation to the employee being embedded into your organisation. And this is where further issues begin to hit home in terms of consent issues, for example, in relation to the data that's captured with regards to that person being an employee of your organisation and what that means with regards to the data that's captured in that regard. You then have more specific issues, some of which we've plucked out for specific consideration today, such as emails in the workplace, and there are issues that are raised in relation to that. That may also play into areas of monitoring. You may have either routine or specific monitoring issues or programs that you wish to put into place. Many organizations do, almost as part and parcel of normal HR and employment practices. And we'll look at some of the issues that are raised from a data protection perspective there. And then we have more specific issues such as data subject access requests. Now, although that appears on the left-hand section of the slide in terms of post-employment, that could appear at any stage in the life cycle. You may find someone at pre-employment stage decides to file or submit a data subject access request. Often they may not be happy with the decision around why you've decided not to employment, and they might want to know why you made that decision. And they may well use the subject access as a means to understanding the why question at that stage. You may find that during employment, individuals have issues that again lead to the why question being posed through a subject access request. And again, we see this typically thrown into the life cycle at post-employment stage or just prior to post-employment if an organisation is going through a reorganisation or redundancy or similar type of exercise where again an employee might ask why me type of questions, which are often facilitated through a data subject access request. So although that appears on the left-hand side, that could actually apply at any particular part of the life cycle. But this is the rather simplistic but bite-sized chunk view that we've taken to actually look at this subject for today. I mentioned the current legal framework, and let's just toy on this just for a moment. Most of you are probably familiar with the legal framework. We have the 1995 directive, under which all 28 member states in Europe have implemented their own local data protection law. In the UK, we have the Data Protection Act 1998, and in Germany, as Thanos will explore later on in the presentation, there is local legislation in Germany which also implements the 1995 directive. Most of these laws will have a regime for penalties and sanctions if there is a breach or infringement of the obligation and framework that's set out under the local applicable data protection law. often we hear the question, how do we comply with the directive? And if you're an organization, then the real question is, how do you apply with the local applicable law depending on which country you're impacted by, and not the data protection directive as an overarching EU law. And in some cases you may well have to comply with several of the local data protection laws across Europe, again depending on your operations, and where, for example, you may have employees who are localized in different parts of your operations spread across Europe. You may well have centralized operations which also gather data, and therefore creating a local data controller entity, and therefore a local applicable data protection law in a specific member state in Europe. So just important to keep in mind that several laws or a local applicable law will apply depending on what your HR operations are in that particular jurisdiction. There are 8 data protection principles which we will pervasively touch on as we go through the presentation today, so I won't go through that in detail right now. But it's worth noting that the key concepts that are relatively common across all member states are those which are really handed down from the Data Protection Directive. So the concept of personal data, which very clearly will touch on employment data, prospective employee data, and ex-employee data, as well as different types of staff who perhaps may not be employees but may be contractors or maybe temporary staff, are all data-rich individuals, and their personal data will inevitably be caught by data protection laws. Sensitive personal data is an area which very specifically impacts on the HR environment, and it's hard to see how it doesn't. The moment you start collecting data on racial or ethnic origin, information around disability, then which is often mandated under employment laws to, for example, look at issues of anti-discrimination within the workforce environment. Then these are all different types of sensitive personal data, and again, all captured and covered by the local data protection law. Processing is a very wide definition indeed. It captures so many different types of information handling. In fact, any type of handling of employee data or HR-related data will amount to processing under data protection law. We then have concepts of data controller, which is quite typically the employer. We then have the concept of the role of the data processor, which is usually a third party that is engaged by the employer, for example, a payroll provider, or maybe even the system providers that look after your human resources management tool. They are typically classed as data processors. They incidentally handle and manage your data as part of performing the service. And the data protection legislation has a role to play in relation to how a data controller manages a relationship with its data processor, the type of contractual language that's required, the type of data processor provisions, and also the extent to which due diligence requirements kick into that as well. Beyond the core data protection law itself and the framework, we have other data and information laws which also apply within the HR environment. If you have a very large workforce, for example, which applies in certainly a retail type of business, then it's not that unusual to use your staff database as a potential retail marketing database as well. And you might do this rather discreetly through clubs and loyalty and staff incentives, or it might be something a bit more upfront. But the e-privacy regulations, which focus on the ability to market to individuals, will have a role to play there in terms of consents, permissions, opt-in or opt-out requirements, depending on the channel-specific communications. REPA, or the investigation of, the Regulation of Investigatory Powers Act, looks at the interception of communication. So if you're in the monitoring space and you are looking at the communications of employees, then there is a law that very specifically governs how that has to be carried out for it to be lawful. So the starting point on REPA type of legislation is, it's unlawful to intercept communications unless you can find the appropriate carve-out to hang your hat on. Encryption often applies where you're transmitting data, human resource data, allowing it to be accessed across internal systems. And also, if you're using more bespoke technology or technology devices such as radio frequency identification, RFID, maybe in building swipe entry or exit cards, that is also regulated and governed as well. So there's a further layer that applies in that regard. But let's just start to toy on some of the areas that I mentioned that we're specifically going to cover today, starting with pre-employment. Employers often carry out pre-employment checks prior to making an offer of employment to an individual. Many employers will be concerned about criminal convictions and or ongoing involvement in perhaps illegal or unlawful activities. Indeed, in some industries, it is a requirement that employers run checks to ensure that new hires do not have any criminal convictions. Equally important is the concern about unsubstantiated or indeed false claims of experience on CVs, and indeed unexplained gaps in employment history. And here's where you get into realms of verification. And certainly with the rise of social media, many applicants will have a significant online profile. It is tempting to use this in order to confirm what applicants have put on their CVs. And in this regard, companies should be aware, however, that there are risks to doing this. And we'll look at some of those risks in a moment. As far as criminal record checks are concerned, a balance needs to be struck between protecting vulnerable groups of people and maintaining high professional standards in the service industries, as against ensuring that civil liberties are protected, for example. With this aim in mind, the Protection of Freedoms Act 2012 came into force in September 2012. Now, the Protection of Freedoms Act, or the PFA, introduced a new disclosure and barring service, often referred to as the DBS. And the DBS replaced the Criminal Records Bureau. So the DBS can now carry out 3 levels of checks on employees: basic, standard, and enhanced. Most companies, if they carry out criminal records checks at all, will use the basic check. This is only valid at the date of issue and does not contain any information about overseas convictions. So this is quite a UK-specific particular checking facility. The basic check does not always provide the information that's required, and employers may, in any event, be wary of asking for the check in light of a recent Court of Appeal decision in the case of R versus the Chief Constable of Great Manchester, which is determined this year. Here, the Court of Appeal decided that complete disclosure of convictions and cautions through an enhanced criminal records check may breach the right to a private life that is guaranteed by the European Convention on Human Rights, unless the convictions are relevant to the employee's suitability for employment. The decision is currently being referred to the Supreme Court, so this issue is likely to be reviewed again in the coming months, and we will report back in the usual way through the Global Data Hub on that issue. Another thing that employers need to be wary of is that some convictions can be treated as spent where the sentence was of a certain type and a period of time has elapsed since the conviction. In the event that the employer comes across information regarding spent convictions, then this information should not be considered for the purposes of recruiting or indeed continuing the employment of an employee specifically linked to that information. I talked about social media and pre-employment checks, and increasingly companies are using social media screening to access background information about potential recruits. And in many ways, this provides a good indicator of their suitability for the role and the threat that they may potentially pose to the security, as an example, the security of a company's confidential information. Screening may also be useful to check whether current employees are disclosing information which may damage a company's reputation, or using social media to perhaps bully or harass other colleagues. And this may become evident through looking at social media profiles. Companies should make it clear to prospective employees, and probably do so on the application form or other early stages of the application process, and also to current employees, perhaps in contracts or social media policies, that such checks will be carried out. And companies should explain what form these checks will take and why they are considered to be necessary. Screening should, however, be used sparingly. The UK Information Commissioner's Office specifically prohibits the use of social media screening for arbitrary checks on an individual. All companies will need to ensure that they have a good reason for conducting screening, and that such screening only goes so far as is necessary and proportionate to achieve these specific aims. The level of screening which may be appropriate, if any, excuse me, is likely to relate in part to the role the individual has within the company. So the role should be risk assessed and the appropriate level of screening then conducted. Equally, media screening should only be used if another method of finding or verifying information, such as contacting referees, cannot be used. Organisations will need to be aware that unless they are operating in a regulated sector or working within vulnerable areas of society, it is unlikely to be considered appropriate to carrying out ongoing checks on employees as a matter of course. It may, however, be appropriate to check employees' social media use if the company has a reason to believe that its information is being disclosed or another employee is being harmed or perhaps upset by online comments. Where any type of check is being carried out on an employee or applicant, they should be aware that this is being undertaken, and companies should be wary about using checks indiscriminately. Tempting and as easy as it may be to use social media to check up on employees, this really should be avoided, and only those checks which have a legitimate commercial purpose should be carried out. We're also aware that some companies will adopt a very specific position as to whether or not they, for example, will not include social media checks. And that is often, as we've seen, as part of the demonstrating the culture of a particular organisation. Moving on to employment challenges as far as data protection and the employment stage is concerned. It's inevitable that employers are going to be required to process the personal data of their employees during the employment relationship. The Data Protection Act in the UK is typical in that it provides that personal data must not be processed unless at least one of the conditions in Schedule 2 of the DPA is met. The Schedule 2 conditions, which are most likely to apply in an employment context, include, firstly, where the data subject has given his or her consent to the processing, where processing is necessary with the performance of the employment contract, where processing is necessary for compliance with any legal obligation, and where processing is necessary in order to protect the vital interests of the data subject. Many aspects of processing employee data do not require specific consent to fall within another Schedule 2 condition. For example, providing information to the local taxation part of your local government infrastructure, so in the UK, HMRC, if that's required to enable salaries to be paid via payroll, then it's likely to be deemed necessary for the performance of the employment contract, as opposed to being a purpose that is reliant on consent. Many employers, however, prefer to obtain employee consent to processing rather than rely on alternative Schedule 2 conditions. Express consent is perceived as transparent. Although difficult to challenge, it involves the buy-in of the employee if it's seen as transparent and expressed. Consent is also perceived as being less open to the vagaries of interpretation of other conditions, which often involve an employer having to make its own judgment about whether or not processing is, for example, for a legitimate interest. As such, consent is generally regarded as a more reliable and play-safe option at the moment. It is common in UK employment contracts, for example, to include a data protection clause in which the employee grants consent to the employer processing their personal data in connection with their employment or the business of the employer. Such clauses usually permit the employer to disclose or transfer personal data to other employees or to any group companies or affiliates of the employer, and will typically also include consent to the transfer and the disclosure of personal data outside of the European Economic Area. So the 8th principal data transfer type of issue is also something we see wrapped into this particular point as well. The benefit to an employer of including such a clause in an employment contract is in demonstrating that an employee is granted generic consent to processing personal data for employment-related purposes. This removes the inconvenience and administrative difficulties of an employer being required to ask an employee to consent to each specific incident of processing. There are, however, difficulties in ascertaining whether general consent in an employment contract or policy satisfies the conditions of data protection legislation, and in particular that is the case with the UK Data Protection Act. Although the DPA itself does not define consent, under the Data Protection Directive, if you use that as a source of interpretation, consent by an individual must be freely given, specific and an informed indication of the employer's wishes by which he signifies his agreement to personal data relating to him being processed. And if you want to see where that's quoted, that's Article 2H of the EU 1995 Directive. And the consent must be unambiguous, which is contained in Article 7. Positive indication of consent, such as a signed employment contract, will usually be sufficient to establish that consent is seen as being unambiguous. It can be harder to establish this where consent is, for example, implied, perhaps because the failure to complete an opt-out, or perhaps an objection box, which otherwise is seen as a signification of implied consent. The requirement for specific and informed consent will also usually be satisfied provided that the data protection clause in the employment contract is well drafted and clearly informs the employee of the type of personal data that will be processed, the purposes of such processing, and makes clear that processing will be continued and repeated throughout the employment relationship. Where any particular instance of processing strays outside the scope of what is envisaged in the employment contract, it will be hard to rely on the employment contract to establish that the employee has actually given specific consent and that informed consent to that particular form of processing really exists. The condition of consent that causes the most problems in practice is the requirement for consent to be freely given. Now, if we look for a moment at the UK Information Commissioner's guidance on this, he considers that the extent to which consent can be relied on in the context of employment is limited, and that's a quote. Primarily because the inevitable power imbalance between the employer and the employee generally undermines the extent to which an employee can be said to have freely given their consent. If the consequence of not entering into an employment contract containing a consent clause is that a job applicant is not offered a position, or an existing employee's continued employment or provision of benefits is conditional on entering into such a contract, then it is questionable whether the employee has any realistic alternative and is actually genuinely freely consenting. Due to the difficulties in establishing that employee consent meets the requirements of the DPA, employers should consider why in practice they need to process an employee's personal data, and ideally should be prepared to identify another Schedule 2 condition to support their reasons for processing. As was noted, in many cases, processing of an employee's personal data will be necessary for the performance of the employment contract and therefore will be legitimate, whether or not an employee has actually provided their specific consent. And considered approach which jointly combines employee consent and another legitimate schedule condition to hang your hat on will be much less open to challenge at a later date. So moving on to the topic of emails and the challenges in this regard, as we've reported in previous articles and commentary in the Global Data Hub, and we did so in April, employers can track the performance of their employees by implementing clear and open monitoring systems. We look at the wider tools open to employers who are seeking to manage internal and external employee interaction within the workplace proactively to ensure that their business interests are protected against. And this often becomes the issue whether or not it's acceptable or unacceptable as far as the use of communication systems of the employer are concerned. The initial step for an employer is often to implement a policy dealing with the acceptable use of workplace email. This should usually cover both private and work-related correspondence and aim to provide broad guidelines which take the needs of the wider business into account. The explosion of the use of personal devices means that any policy should also cover emails that are sent from mobile work devices as well as a traditional office desktop. For example, the policy should include issues such as a clear statement of an employee's accountability in terms of their workplace communications. Clear examples as an illustration of unacceptable use, such as sending emails containing obscene, racist, sexist, or defamatory content. A statement making it plain that any breach of the employer's policy may result in disciplinary action, including dismissal. An unambiguous explanation of when, how, and why workplace emails will be monitored. Any policy implemented by an employer should be openly communicated to staff in order to ensure that employees are aware of what's expected of them, as well as the potential consequences to the employee of any breach of such a policy. Practically, a written policy should be included in the staff handbook or a reference to it, and clearly brought to the attention of new employees as part of, for example, their induction process. Ideally, all employees should explicitly consent to the terms of the policy by signing a statement making it clear that they have read and understood the acceptable use policy and agree to abide by its terms. Employers should be alive to any changes that may be required to be made to the policy, especially in this rapidly evolving area, and ought to communicate any updates to employees and provide regular training on the acceptable use guidelines and their practical impact. At the same time as implementing an acceptable use policy, employers should, as a matter of best practice, also consider devising a risk management policy which comprehensively sets out any email retention, deletion rules which are going to be applied. Any policy relating to the use and misuse of employee passwords and whether any monitoring and filtering software, for example, is to be utilized, and if so, how it will be utilized. Looking also at a computer security policy, identifying any procedures or tools to be followed or used in the prevention of any hacking or interference with an employer's system or data. Looking at a clear strategy in terms of software to be used to monitor and filter employee email traffic and internet usage. Any acceptable use policy should also be accompanied by an unequivocal statement which covers the circumstances in which the employer will monitor an employee's use of email systems. Previous articles on this area have also looked at the legislative framework that more widely surrounds workplace email monitoring, and you'll be able to access this on the Global Data Hub if you want further reference to that. Suffice to say that the benefits of putting into place a robust email monitoring procedure are clear. Not only does it ensure that the security of any IT infrastructure is sought by prohibiting certain activities and potentially recognizing the source of security breaches, it also serves as a deterrent to employees perhaps otherwise seen as wasting company time, for example, increasingly or more than they should do using private email accounts, etc. In terms of enforcement, managers need to be aware of their responsibilities. Making sure that employees understand and adhere to the rules will be critical. With regard to the practicalities, employees should also be extremely careful not to cross legal boundaries when monitoring emails in the workplace. Essentially, employers will need to remember that monitoring shouldn't unnecessarily intrude on an employee's privacy and should be proportionate. It is also key that employees are made aware of any monitoring and the purpose it is serving, and any overtly personal email correspondence shouldn't be opened, or where it is deemed necessary for such private emails to be opened, this is backed by a very clear justification and decision-making matrix, which is perhaps set out in a privacy impact assessment. Finally, on the UK section, I just wanted to look at the issue of, as we title it, discovery by a different name, or data subject access requests. Employers inevitably process personal data as part of their employment environment, and that's something that's very clear. Under the data protection legislation, employers have to observe the rights of data subjects, and one of those rights is that employees can access their personal data, provided it is a valid request, and the data that would then need to be provided would be the personal data of which the employee is the subject, with also ancillary information around the purposes for which the data is held, and also other information around the recipients of that information. This is set out in all local implementations of data protection legislation under the guise of subject access requests, which are applications made by individuals to enforce this right to access their data. Although in the UK and certainly other countries, we've seen that the UK courts have had to look at the issue of subject access requests alongside other contentious matters, particularly in the workplace environment. And the UK courts have already commented against subject access requests being used for fishing expeditions or a form of pre-disclosure exercises for the purposes of litigation. And employees are increasingly using subject access requests to obtain information to use in claims against their current or ex-employers. Subject access requests can be particularly useful where the information the employee requires is not particularly available through traditional disclosure. And it commonly arises where the employee either cannot demonstrate that the document in question is relevant to the ongoing litigation, which is quite a narrow test in that regard, or does not want to go to the trouble of actually doing so. Subject access requests potentially give employees access to a wider range of documents and information in addition to or in conjunction with traditional disclosures. Employees who use subject access requests, and remember they're only currently subject to a maximum fee in the UK of £10 sterling, often see this as a simple and cost-effective way to be difficult and to increase their ex-employers' use of management resources and legal costs towards locating the data. Employers have to do this within a framework of 40 days of receiving a properly submitted subject access request. Employees are not required to explain the scope of their search, but are under a general duty to act fairly when processing personal data in this regard. And it's seen as good practice to give a basic explanation of the approach that's taken. However, it's not necessary and may not be deemed appropriate depending on the type of request and perhaps the ultimate motive that you know as an employer sits behind the request, although it's important to note that under data protection law you cannot question the motive of a data subject. The rules around this are set out in a particular article that we've also published this month if you want to look at the very specific areas that cover this. So employers can be aware of exemptions that are available, for example, for vexatious requests or for onerous requests, or if there are issues around the scope of the emails or other electronic documents that are subject to the search. And also there are exemptions available, and we go into detail on this on the articles that supplement today's webinar that's available on the Global Data Hub. The attraction of subject access requests for employees is obvious. It's a cheap and easy way to obtain a broad range of information which is useful or may be useful in proceedings against the employer or ex-employer, whilst in causing the ex-employer headaches and resource issues in terms of addressing these particular issues. So employers need to be well prepared to deal with subject access requests and need to have a policy and procedure and control environment in place to deal with subject access requests as efficiently as possible and with as little disruption to their business as possible, because these can be very resource heavy. And remember, you are dealing with a fundamental right that is enshrined in data protection law to allow data subjects to access the data. So tread very carefully in this regard. So to take a look at the German aspects that impact on some of these areas that I've mentioned today, I'm going to hand over to Thanos to walk us through some of those issues. Thanos.
Thank you very much, Vin. From a German law perspective, there are some similarities, but also some differences from the situation in the UK. Vetting and pre-employment checks are important tools, but employers in Germany must take a few issues into account. Pre-employment checks involving social media and health data have caused controversy in Germany in the past. Therefore, employers should be cautious when using them in the recruiting process. As a general rule, an employer has the right to collect and process all information necessary to make a decision about whether or not to employ an individual. This may also include medical examinations. Besides, as in the UK, in some industries it is a requirement that employers run checks to ensure that new hires do not have any criminal convictions. Collecting information from publicly available sources, however, such as legitimate websites, is generally compliant with German data protection laws. But researching on social networks which are not openly accessible is critical. Openly accessible information from social networks which have a clearly sole private purpose, like Facebook, is not in line with German data protection law. Something else may apply to social networks which are closely linked with recruiting or employment purposes, like, for example, LinkedIn. For those social networks, most legal commentators in Germany hold that when information is publicly available via, e.g., search engines, the individual has given its implied consent for a collection of such data. With regard to medical checks, employers may ask health-related questions and conduct health-related screenings where the outcome is relevant for the position in question. For example, it is of importance to know that a candidate applying for a driver's position in a logistics company does not have a medical history of alcoholism, or that a future nurse has not been tested as HIV positive. Similar to the situation in the UK, however, such screenings should be used sparingly. On the other hand, the use of medical examinations which aim at obtaining information that the employer would otherwise not be able to ask the applicant is not compliant with German data protection law. For instance, the employer should not conduct a pregnancy test because under normal circumstances it is also not allowed to ask pregnancy-related questions. Moving on to the next slide regarding consent, employers should be aware that consent is only one of several legal grounds to process employee data. Under German law, valid consent requires that employees are informed appropriately. Thus, an employer should not use general terms, but rather explain the specific purposes for which personal data will be used and, ideally, explicitly name third parties to which personal data is transferred. In general, there are few limits to consent under German data protection laws. Often, the validity of consent in employment relationships is seen as critical by data protection authorities because there are cases where it may be assumed that consent is not freely given. This may be the case where the employee has no real choice but to agree to the employer, for example, in relation to consent for a monitoring of the use of a company's IT equipment. Here, most employees would not have a real choice because for most jobs, using the company's email account is essential to fulfill the employee's tasks. In turn, consent would be invalid. However, German case law assumes that there is no issue with regard to freely given and therefore valid consent, where the employee obtains some kind of advantage in return. Finally, employees should bear in mind that consent may be withdrawn. Thus, consent should not be used widely and as a sole means of processing, because if withdrawn, the employer may be left with no legitimate grounds to process the data. Moving on to the next slide regarding employee emails, German law is somewhat different from the situation in the UK when it comes to acceptable use policies, as Vin described before. Employers may completely prohibit or partially allow private use of a company's email services by appropriate policies. A violation of such policies may provide grounds for termination of an employment contract. However, the term private use is not legally defined. There have been several attempts by German courts to distinguish private from business use. Unfortunately, however, the distinction is not clear. How do you classify an employee's email to another employee in order to arrange a social event? Is it private or is it company use? Therefore, it is up to employers to clarify the extent of tolerated private use via appropriate policies. The role of such policies is crucial in this context. They should be as precise as possible and include, for example, appropriate channels of communication or specific time windows of permitted use. For example, an employer may allow the use of a software like Skype, but only during business lunchtime hours. It is also important to note that employers that do not provide any guidance may run into issues of criminal liability. An employer may be held as supplying an IT infrastructure to its employees and, in turn, as offering telecommunication services to them. As a consequence, the secrecy of telecommunications could apply to employee communication. A violation of the secrecy of telecommunications, for example, when accessing emails as part of a company's compliance mechanism, may lead to criminal charges against the director of a company. Moving on to the next slide, regarding a monitoring of employees, we can draw upon some German case law principles on video surveillance. German case law is rather employee-centered. This means that any implementation and operation of monitoring measures must take the privacy rights of the employee into account. In principle, monitoring of employees should not be covert and should not result in full surveillance of individuals. With regard to video surveillance measures, the following issues should be taken into account. The employer should assess which areas should be monitored. The employer should also assess whether the monitoring is appropriate, both in terms of how it is carried out and its duration. Further, how this might affect the privacy rights of employees. And, in addition, whether this is necessary as a result of a specific past incident or whether this is implemented as a generic policy. With regard to the monitoring of a company's IT infrastructure, as mentioned before, the implementation of appropriate policies is crucial. If a private use is not regulated and is not tolerated over a certain period of time, German case law recognizes that employees may actually have acquired a right to use the company's IT infrastructure privately. Moving on to the next and final slide for the German perspective. With regard to subject access requests, German law differs somewhat from the practice in the UK. While employees have a right to request information, similar to the one in the UK, about all the personal data stored on them, access requests are not often used tactically for phishing expeditions by employees or ex-employees. Besides, until recently, an employee could only inspect files stored on him during an ongoing employment relationship. However, the Federal Labor Court held recently that an employee is also entitled to access information on him after termination. The employer may be entitled to reject this request of the employee if, for example, the data is classified or due to the nature of the data, namely due to overriding legal interests of a third party. In addition, a request may be also turned down if disclosure of personal data would seriously endanger the commercial interests of the employer, unless notification of the employee outweighs this danger. So, subject access requests are subject to a balancing of interests between the interests of the employer and the employee. So much for the German perspective. Vin, I believe we have some polling questions.
Thank you, Thanos. In the usual way, and our regular attendees will know, we like to gauge your views on particular questions in relation to today's subject. Now, these views will be aggregated views that we will share back with you in a moment. So the polling questions are now open. So we'd like to hear your views in relation to, first question, are your policies a one-size-fits-all solution, or do they allow for country variation? The policies in your HR environment, touching on the issues that we looked at today, are they one size, are they localized completely? Are they a global policy with allowance for local variations? Or maybe you don't know what the coverage is. The second question is, do you think that your employees use subject access requests as a form of discovery tool? So you can click yes, know, or don't know? And finally, in terms of monitoring in the workplace, did you conduct a documented privacy impact assessment before you embarked upon the monitoring activities that you have in the workplace? Again, yes, no, and don't know. If you can click one of those options, that will be very helpful, and we will come back to you in a moment or two as those results are gathered and let you know what those aggregate views are. Whilst we're waiting for those to come through and whilst you're clicking away, I'll just mention that our next webinar is going to be on the 17th of September. There will be no webinar in August over the holiday period. So we do hope you can join us on the 17th of September. We'll be looking at the topic of data security, particularly as we are hearing much more now about data security risks, and particularly cyber security risks, and the issues that you should be concerned about. So we will explore that topic on the 17th of September, and we hope you can register and join us for that particular webinar. That's on the 17th of September. Whilst we are waiting for those question responses to come through, I can see we've got one or two questions that have come through, so maybe we'll just look at those questions whilst we're waiting for those polling results to come through. There's one here which, Thanos, I believe it's perhaps for you. And the question is quite a long question, so perhaps you can give a brief response if that's possible.
Sure.
With regard to the risk of criminal liability that you mentioned when monitoring employees' email, how is the current view of German courts on the question of classifying the employer as a telecommunications provider?
Thanks for the question. There have been a couple of German courts which ruled against the classification of the employer as a telecommunications provider. One judgment was in the past year and one was from the year before that. However, neither the regulator nor the legislator have made an attempt at resolving this issue so far, and therefore we believe that most legal commentators still provide that the employer must regulate the issue of private use in order to avoid such risks.
Thank you, Thanos. Okay, just coming back to the polling questions, we can see that the results have come through. So for the first question, are your policies a one-size-fits-all solution, or do they allow for country variation? Some interesting responses here. So in terms of answer A, one size, only 11% have clicked for that option, and only 14% of you have an option that is localized completely, so very local specific. The bulk of our responses are for answer C, where you have a global policy with a local allowance variation. So it's over 70% voted for that one. So quite a localized view being attached towards a global policy. So that's interesting there. The second question, do you think your employees use subject access requests as a discovery tool? Wow, 50% of you say that you believe they do, and then the rest is split between no and don't know. So I'm not entirely surprised. With most of the subject access requests that we support our clients with, we find that they are one way or another linked to some form of discovery type of motive. So not surprised with that. Most of you think the answer is yes there. The third question is monitoring in the workplace. Did you conduct a documented privacy impact assessment? Interesting. Only 25% of you say that you did. 29% of you say you didn't. And almost 40% of you say that you don't know whether or not the answer is yes or no. Now, why do I say this is of interest? Because under the proposed EU data protection regulation, aspects of data processing such as monitoring in the workplace will require a formal privacy impact assessment to be carried out, and in some cases also will also trigger requirements to socialize or even seek approval of that impact assessment through your local regulator, and perhaps even data subjects involved as well. So thank you very much for giving us some responses there. We just have a moment, so I'm just going to take one final question. I'm conscious that we do have other questions that we haven't come around to, and we will respond to you individually, but I think I'll just take this question. And the question is, how will the EU regulation proposal change SARs, or subject access requests? In a nutshell, subject access requests under the proposed EU regulation will be impacted upon. First of all, because the definition of personal data under EU regulation is wider than the definition that we have right now, arguably more information will be deemed to be personal data, and therefore will constitute personal data that is disclosable under subject access requests. The fact that there will be no fee for subject access requests may lead to an increase, because it might not deter those who currently are deterred by the fee. There will be a shorter time frame, and that's certainly shorter for us in the UK. In the UK, we're used to a 40-day time frame. That will come down to what appears to be a 30-day time frame. So we're looking at really a 20 working day time frame. And given that more information will be needed, you might see an increase in subject access requests. Shorter time frame, it will have an impact on you. And also, more information is required, certainly around the area of data retention periods as applied to subject access requests. So if you pose a question, we will get back to you individually and answer those questions, because we have reached the end of our allotted time. Final reminder, our next webinar will be on the 17th of September, looking at the issue and the topic of data security. And we really hope you can join us and attend the September webinar. So today, from me, Vin Banj in the UK, from Thanos Ramos, joining us from our team based in Germany. Thank you very much for joining us today, and goodbye.